Welcome to the inaugural high school moot court in Ohio. I'm Stephanie Bucher with the Ohio Supreme Court's Office of Public Information. We're coming to you from the Thomas J. Moyer Ohio Judicial Center in Columbus, where more than 70 students from 13 high schools will be participating in today's event. Moot Court is a program of the Ohio Center for Law-Related Education that focuses on the appellate court process, an often misunderstood part of our judicial system. The 2014 Moot Court case, Charlie Charleston v. State of Ohio, centers on the Fourth Amendment, which is the right against illegal search and seizure, and a hypothetical stand-your-ground Ohio law. In this year's case, a high school student arrives at his parents' house at night and sees a stranger approaching as he gets out of his vehicle. As the stranger gets closer, the student begins to feel threatened, draws a gun, and shoots and kills the stranger. When police arrive, they search the student's car and discover incriminating material. The student is ultimately convicted of second-degree murder, and in his appeal argues he acted in self-defense and that police violated the Fourth Amendment in the search of his vehicle. Moot Court incorporates both written and oral argument components. The students have submitted their written briefs in which legal issues of the case have been presented. And prior to the competition today, the students' written briefs were reviewed and scored by a panel of volunteer attorneys. Today, 16 teams will present oral arguments for both sides of the case against other competing teams. A team consists of 2 student attorneys and a timekeeper. The written briefs are judged on a number of different components, including organization, grammar, analysis, and persuasiveness. Arguments are evaluated on the application of the law to the facts of the case. Now, by focusing on the applicability of constitutional law to current legal issues, Moot Court offers the students an opportunity to develop an understanding of the Constitution and the judicial system while strengthening their writing, speaking, and critical thinking skills. And if you would like some more information about this program or any other by the Ohio Center for Law-Related Education, you may visit their website at oclre.org. Now, let's watch as our students present their arguments in the Moot Court 2014 state competition.
Case of Charleston against the state. Appellants ready to proceed?
Yes, Your Honor.
Okay. Appellees ready to proceed?
Yes, Your Honor.
Feel free to proceed.
Before my time begins, I would like to introduce my team. My name is Grant Osborne, and along with my co-counsel, Evie Kearns, and my timekeeper, Lindsay McCready, we represent the petitioner in this case. May I proceed?
Please.
Your Honor, we are here today on 2 issues. First, whether the lower courts improperly denied the petitioner's motion to suppress evidence obtained from his iPad after a warrantless search. And second, whether the lower courts improperly decided that the petitioner had not proven by preponderance that he was entitled to immunity under Ohio's Stand Your Ground statute. Now, the facts are as follows. The petitioner was going to his parents' house. When he got out of his car, a large man in a ski mask and a blunt object approached him and said, "Hey, you," in an aggressive voice. So the man who was the victim kept walking towards the petitioner, and the petitioner pulled out a gun and said, "If you move any closer, I'll shoot." So the victim slipped on ice and flailed his arms towards the petitioner, and the petitioner perceived that as an attack, and then he shot him. So the petitioner left the scene, went to his friend's house, called the police, and the police said to come back to the scene, that they were already there. So he went back to the scene, and the police arrested him and searched his car and his iPad. Now, we are here today because we take the position that the petitioner did have his rights violated by this search of the iPad. So I'll be addressing 2 main issues. First, the car, and second, the iPad, whether or not they were both reasonable. So in Schimmel versus California, the Supreme Court decided that a warrantless search incident to arrest may be conducted for the search may contain the person of the arrestee and the immediate area where he may reach. Now, the Supreme Court of the United States later in New York versus Belton just determined that there are several characteristics of a car which make that searchable. For instance, it may be driven out of the jurisdiction, so the police would no longer have any right to that car. So this, they determined that a car was more searchable because of these inherent factors which make the evidence far more susceptible to destruction than they would if they were not in a car. Now, in Arizona versus Gant, the Supreme Court of the United States determined that Belton was too broad, and they honed that in to just be an application of the Chimmel case to a vehicle. What they determined was that a car can be searched if it meets one of the two criteria under Chimmel. They may search the person after he is arrested, or they may search his surrounding area, but also they included Thornton, which was a case where they determined that they can search the car because of those inherent characteristics which I mentioned earlier. The facts in this case do not meet the Thornton test. A police officer may search a car incident to arrest if he reasonably believes that there could be evidence related to the crime in the car. He saw a gun. The gun was in plain sight. There is no question that the gun could be taken without a warrant. But by continuing that search, they violated the petitioner's Fourth Amendment rights. After they
Wasn't
found
the iPad in plain view?
the iPad was in plain view. However, the police had no reasonable belief that that may contain incriminating evidence. When they were searching, they took the gun, and they should have stopped there. When they continued the search and took the iPad, first they had to turn the iPad on, and then they opened the desktop. Now, the desktop had an icon labeled My List, which was a word processed document. This still had the police had no reasonable belief that this contained any incriminating evidence, yet they still searched this document. So even if you just apply the Chimmel standard to this case, then this would be an unreasonable search. However, the Chimmel case isn't the only case. An iPad deserves a heightened expectation of privacy, just as a cell phone and a laptop computer did. And Ohio versus Smith ruled that both of these did have a heightened expectation of privacy.
Does it matter that there was no password placed on the iPad?
It shouldn't, because regardless of what the security features on that iPad were, it still should not be searchable because it has a heightened expectation of privacy. For instance, in Ohio versus Smith, the ruling was that a cell phone can never be searched without a warrant. That same standard should apply to an iPad. Now, a cell phone and a laptop share many characteristics with an iPad, and this is important because in Ohio versus Smith, the argument was made that because the phone in the facts in Smith versus Ohio was not a smartphone, that it should not have the heightened expectation of privacy. But the Supreme Court of Ohio ruled that it did have a heightened expectation of privacy no matter what kind of phone it was, because they predicted that 10 years from now, there may be no distinction, or it may be very hard to tell because there may be 50 different iPhones, and they would all have slightly different features. Now, the future is now in this case. All the variance between an iPad, a computer, and a phone, all those lines are being completely blurred. There are now phablets, which are a combination of a phone and a tablet. There are computers with a removable screen that can be used as a tablet. This should have the exact same expectation of privacy as a phone and a computer, which is a heightened expectation of privacy.
Why wouldn't the police have been concerned about somebody being able to remotely wipe the iPad?
Well, because there is no evidence in the facts given that there was anything other than that there was any cloud-based computing done on this iPad. So, based on these facts, there was no reasonable belief that all of this evidence could have been deleted while they were getting the warrant. So, based on these facts, the court should adopt a similar standard to that of a cell phone and a laptop computer, and this should not be a reasonable search because it contains so much private data like a cell phone and a laptop computer.
But are you telling me that an iPad unconnected to the internet is anything different than a notebook,
Well,
paper
absolutely.
notebook?
The Supreme Court determined that a cell phone, even if it's not a smartphone, cannot be searched, even if it's a non-smartphone does not have any connection to the internet at all. Similarly, they stated that a laptop computer can never be searched, no matter where, it does not matter whether or not it has connection to the internet. So if a similar standard is adopted to a similar product, then there should not be, then an iPad should not be searched without a warrant.
But didn't the police find the gun right next to it?
Yes, and they did. And they, even if they did, though, have a
Please
right
continue
to
to
search,
answer the question.
even if they did have a right to search the rest of the car, they did not have the right to search the iPad, since that should warrant a higher expectation of privacy, like a computer and a cell phone.
Thank you.
Thank you.
May I proceed?
Yes.
Before my time begins, I'd like to reintroduce myself. My name is Evie Kearns. May it please the court. Whether the lower courts, the issue presented today, Your Honor, is whether the lower courts improperly decided that my client had not proven by the preponderance of the evidence that he was entitled to immunity under the Ohio Standard Ground Statute, Revised Code 2999.16 and 2999.32. The petitioner's position today is that it, 1, was improper for the District Court of Appeals to not hold a pretrial evidentiary hearing because it went against the Ohio Standard Ground Statute that says a person is immune from prosecution. 2, the court improperly decided that Charleston did not meet the Ohio Standard Ground Statute. Your Honors, today we maintain that our client is immune from criminal prosecution and that his failure to be granted a pre-evidentiary hearing on this issue greatly impacted the outcome of this case and is not simply harmless error. In evaluating whether to affirm the decision of the Buckeye District Court of Appeals, this court should consider a two-part analysis. 1, whether the reading of the statute requires a separate pretrial evidentiary hearing on immunity, and 2, if so, whether the lower courts erred in not granting a pretrial evidentiary hearing was harmless to the outcome for our client. As to the first part of the analysis, the court must review the clear and unambiguous reading of the statute. Both revised codes of the Ohio Standard Ground Statute state my client is immune from criminal prosecution, and according to the Ohio Supreme Court case, Heinzelman versus Air Experts, if the statute is clear and unambiguous, then it must be enforced as it is read.
Counselor,
Go ahead.
Counselor, isn't the Ohio law modeled after the Florida law with a big difference?
Yes, there are similarities in the Ohio law, or in the Ohio statute and the Florida statute, and in Dennis versus State, it was ruled that a pre-evidentiary hearing is necessary.
But isn't it a fact the Florida statute talks about a pre-hearing, and the Ohio statute doesn't say anything?
That is true, but also,
So if we're reading it unambiguously and clearly, as you say, there's no hearing.
but clear and unambiguously, it states that my client is free from prosecution, and therefore it can be argued that it explicitly doesn't state there should be a pre-evidentiary hearing, but in that case, we could also argue that my client is free from any judicial action whatsoever. My client should not be prosecuted unless it is first decided that by the preponderance of the evidence that he did not meet the requirements for the Ohio statute. Legislators intended for the statute to protect innocent citizens like our client and to keep them from going through the criminal trial if they were simply protecting themselves from severe bodily harm. My client should have lawfully been spared the emotional effects that can result from being criminally prosecuted by way of a pretrial evidentiary hearing, plain and simple.
What relief are you seeking today? For example, if we were to reverse the appellate court's ruling and remand the case back to the trial court to conduct a pretrial hearing, wouldn't that just subject your client to more litigation?
You can argue that being put on a criminally prosecuting case, that it would require more emotional distress, and that in fact he could have been spared of that if he just would have gone through a hearing, which is not being decided at the end whether he is held for first-degree murder, but is being decided whether he meets the statute. He did not have the chance to go through that first.
Well, I think what I'm asking is, that's all fine, but the fact of the matter is that there was no pretrial hearing, and at this point, how do we go back and correct that from here?
Yes, Your Honor. I'm stating that in the beginning, he should have been spared. Now that we realize now that it has gone through the court and he has not been spared for that, but now we are asking for that to go back and to be revised before, because we can't tell what evidence would have made it into the pre-evidentiary hearing.
But we do have the evidence that was heard at the trial.
Yes, we do.
And has there been any placement in the record of any additional evidence?
No, but we cannot determine whether something would have made it into a pre-evidentiary hearing or not. The respondent may attempt to also argue that the statute did not explicitly state, as I said, that the right to a pre-evidentiary hearing, therefore they are not entitled to one. But as I previously stated, it can also be argued that a pre-evidentiary hearing, if not given to a person, then the person should be kept from any judicial action at all. The respondent may cite similarities between the Florida Stand Your Ground and the Ohio statute to rely on the Florida case, Dennis versus State. However, this reasoning is flawed. First, the court must recognize that Dennis' case is considered persuasive and not controlling in this case. Two, you have to take into consideration that these cases are completely different, factual-wise. Therefore, what may have been considered harmless error in Dennis is not considered harmless error in this case. And finally, the court needs to take into consideration that the majority of the appellate court did not engage in an analysis of the Heinzelman case, which is considered controlling. Therefore, they did not rely on the clear and unambiguous reading of the Ohio statute, which states my client is clear from criminal prosecution, immune from it. Furthermore, our client did comply with the standards set forth in the Ohio statute. He was entitled to the use of deadly force because he reasonably believed the force was necessary to prevent great bodily harm. In the heat of the moment, the only thing my 18-year-old client saw was a man, masked, holding a shovel in the dark, aggressively yelling at him. And then after the decedent was warned to stay away, he slipped, flailing the shovel at my client, reasonably making my client perceive that it was necessary to protect himself.
Wouldn't it? But it was winter, yes?
Yes.
And so a snow shovel and a ski mask might not be that unusual?
It might not be an unusual, Your Honor, but it also, that doesn't mean that it couldn't be used as a weapon.
Well, so is that the standard, though? Could be used as a weapon, so...
The standard states that if my client reasonably believes, and in this situation he reasonably believed he was in fear of great bodily harm or death, and so he acted in accordance to that.
I thought we had a trial judge trying the case determined that it wasn't reasonable.
We had a trial judge, but not a pre-evidentiary hearing, and also, the facts should have been determined in a pre-evidentiary hearing to decide whether it wasn't. In this case, it was more used as a mitigating factor and not to state whether he was immune from prosecution.
Okay, thank you.
Thank you.
Appellee?
May it please the court. My name is Abby Neal, and I'm here today with my co-counsel, Danny Owens, to represent the state of Ohio in the case of Charlie Charleston versus Ohio. We respectfully ask that this court sustain the decision made by the previous court as pertaining to the stand your ground law and the decision to not exclude relevant information found on the suspect's personal communication device. I will justify this viewpoint with the following argument. Though the Fourth Amendment prohibits warrantless searches, a few specifically established and well-delineated exceptions do exist as sustained by the Supreme Court and apply in this case in Katz v. United States. One exception, established in Chino v. California, is a search incident to lawful arrest. The Supreme Court clarified its decision of Chimel in Arizona v. Gant, holding that there are two justifications for a warrantless search to be reasonable. A, the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search.
Does that even apply here?
Yes, it does.
Okay, how?
After Charleston had shot the victim, Jack Slater, he climbed into his car and drove to a friend's house. During the entire time of the drive and his stay at the friend's before deciding to finally call 911, as he should have done in the first place, he was in easy reach of his iPad and could have easily called to arrange another death or deleted information that would be relevant to the case.
But by the time the police searched the iPad, wasn't he in the back of the car, of the police car?
Yes, but at any time before they detained him, he could have altered the information.
But the search occurred after he was detained.
Maybe he had made a call and not had the chance to delete the data before the police searched the vehicle.
Okay.
Point B, circumstances unique to vehicle context justify a search incident to lawful arrest when it is reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle, such as the iPad. It was determined that these justifications were not present in the warrantless search incident to arrest of Gant because he was neither unsecured nor was there a reason for police to believe that evidence for this crime of arrest, driving under a suspended license, would be found in his vehicle. Here, as the appellant court noted in the first justification, the first justification does not apply, but the search incident with the appellant's vehicle applies to the second justification, as it was reasonable for police to suspend that there was an evidence related to the shooting.
What sort of evidence would the police have? I mean, so I'm struggling a little bit. At the time they conducted the search, I realized they found the document afterwards, but at the time they commenced the search, what would have led the police to believe that there was evidence of a shooting on an iPad?
As I said previously, at any point in time, the police or the defendant could have altered information or communicated somehow to arrange another attack on a person. The appellant had left the scene of the crime in his vehicle. He returned to the scene of the crime. When the police had found the iPad, it was laying unpassword protected, signifying that it is not deserving of any sort of higher appreciation of the Fourth Amendment, as if the defendant had wanted a higher appreciation of the Fourth Amendment as pertaining to this, he would have password protected it.
So it's your argument that if the appellant had put a password on the iPad, that it's the appellant's responsibility to get the level of protection under the law that he wants for his certain devices?
Not precisely, but if he had not wanted any sort of higher protection under the Fourth Amendment for that iPad, he would have protected it by a password, as any person on the street could just pick it up.
If a laptop doesn't have a password on it, are the police allowed to go in it without a warrant?
If they believe that there is reasonable evidence of a crime that pertains to the suspects, for what the suspect was detained for.
But let me ask it this way then. So if the police believe a crime's been committed and they are walking around looking for information and they walk towards a house and the door's open, can they walk in?
That is different from the case at hand, as just any house that doesn't pertain to the case is irrelevant.
Well, let's say it's the house of the person they believe did the shooting.
Then it would be relevant as any sort of evidence that could suggest there was another planned shooting that could occur, or any sort of other information that would be helpful to the case would be found in that house.
What articulable suspicion would the police have had? I mean, the gun was on the seat, right? And the laptop was on the floor of the car, both on the passenger side, right? What reasonable suspicion can you articulate for us that the police would have had necessitating a search of that iPad?
Your Honor, the iPad was face up, suggesting that the suspect could have easily accessed it and used it, and then when he was done with it, just simply tossed it on the floorboard.
Please continue.
The iPad was not password protected, was laying reasonably near the gun, and was already turned on. All the police had to do was pick up the iPod and look at the screen, and they could easily see the document titled My List, which was, in a turn of phrase, a hit list, and detailed numerous ways that people on the list, including Jack Slater, the victim of the shooting, could disappear.
Why couldn't the police have simply secured the iPad and then obtained a warrant and later searched it if they were able to obtain a warrant?
If the suspect had used it to arrange another hit, as I previously mentioned, then it's urgent information needs to be accessed as soon as possible.
And there was no other way for them to, I mean, like they couldn't have questioned the suspect, or?
There's no guarantee that the suspect would answer truthfully. That's all I have.
Further questions?
No.
Any further questions? Thank you.
Before my time begins, I would like to introduce myself. I am Danny Owens, and I am representing the respondent. May I proceed?
Please begin.
The trial court properly decided that the appellant had not proven by a preponderance of the evidence that he was entitled to immunity under Ohio's Stand Your Ground Act. In a state of Heinzelman v. Air Exports, Inc., it was ruled when a statute is clear and unambiguous, a court must enforce it as written. However, if a statute is unclear and ambiguous, a court may look to established statute from another state for guidance and clarification. Here, the court looked at an established statute from Florida when the new Ohio statute was unclear in its meaning applied to this case. Ohio's Stand Your Ground law mirrors certain statute provisions found in Florida law. Both of them state that a person is justified in using force, except deadly force, against another when, and to the extent that a person reasonably believes that such conduct is necessary to defend him or herself or against another against the other's imminent use of unlawful force. The difference between the Ohio and Florida provisions is that Revised Code 2999.32, it states that the person who used deadly force in accordance to Revised Code 2999.16 must prove by a preponderance of the evidence that they are entitled to immunity from prosecution.
And at the trial where this evidence was adduced in this case, the standard was reasonable doubt, correct?
I'm not quite sure what you're saying.
At trial, when the defendant was trying to prove his right to immunity, the standard in front of the judge during the trial was beyond a reasonable doubt, was it not?
If you would let me continue my argument, I will argue that he didn't show by a preponderance of evidence that he was immune.
Okay.
It is not stated in the Ohio Stand Your Ground law the proper procedure to determine if the person has proven by preponderance of the evidence that they are entitled to immunity when it's not an issue of first impression. Because of this, we turn to a Florida case that outlines such a procedure. In Dennis v. State, the Supreme Court of Florida explained the type of analysis a trial must undertake when a defendant files a motion to dismiss, asserting immunity from prosecution pursuant to a Stand Your Ground statute. The Supreme Court of Florida outlined the proper procedure that a defendant must go through in order to dismiss.
And this procedure wasn't followed in this case, correct? In that case, there was a hearing.
There was no hearing in this case.
No hearing, but they found it was harmless error anyway.
Yes, Your Honor.
Okay. And here, isn't the appellant's argument that this was more than harmless error. This was an error in his rights to be immune from prosecution, period.
That is their argument. That's correct.
And why is that incorrect?
Here, the defendant wouldn't be prejudiced, and like the information that they would bring, that Charlie Charleston would have brought in a hearing, would be the same evidence as at his bench trial. He didn't state anything that he would bring any other information in.
But that goes back to my original question. The bench trial the standard was beyond a reasonable doubt, and yet the standard to prove the immunity would have been by a preponderance of evidence, a lower standard, correct?
Correct.
So how's that harmless?
Well, in further cases, it states, well, Florida case, it states that it's not necessarily, it's not necessary to have a pretrial hearing because, well, it says the court must determine if the burden is met in the pretrial stage. But if there's not a pretrial evidentiary hearing, the Supreme Court of Florida states that it's possible for the motion to still be denied. In the case with Dennis, the lack of an evidentiary hearing was deemed as a harmless error as it was not prejudicial to the defendant, and that is the same as this case. Also, the defendant did not indicate that he would have presented any different information from the trial for a self-defense claim, and Charlie Charleston didn't do this as well. He has shown no indication that he will have any different facts, witnesses, or testimony that were not presented in his bench trial. So, therefore, it's a harmless error.
Counselor, though, the Ohio law says that if the defendant successfully proves their case under the stand your ground statute, that they're immune from criminal prosecution. So how can a defendant be immune from criminal prosecution if they can't make any stand your ground argument until they're actually in a criminal prosecution, until they're subjected to a criminal trial?
We're trying to argue that he was not immune, and he could have produced any evidence that he wasn't immune in the trial that he was in.
But wouldn't that have just mitigated his sentence?
His sentence was mitigated, yes.
I just want to make sure I understand the record correctly. The stand your ground issue, was that presented and considered by the court as a mitigating factor, or was that presented and considered as an issue of immunity at the trial level?
The stand your ground was a mitigating factor for his sentence.
And it was not considered with respect to immunity?
No.
So the question is, so why is that sufficient for purposes of, doesn't the statute provide that the suspect defendant would be immune?
Can you repeat your question?
Yeah, so if the trial court considered it only with respect to sentencing, a mitigating factor with respect to sentencing, and the statute provides that if the defendant is able to demonstrate by a preponderance of the evidence that the stand your ground statute applies, that they're immune from prosecution, then how do we know, is there any indication in the record what the trial court would have done with respect to immunity versus mitigating the sentence?
In the trial court, he was considered for immunity. However, he did not prove by preponderance of their evidence. However, it was still used as a mitigating factor.
Thank you.
In this trial, appellant had failed to prove by preponderance of the evidence that his use of deadly force on Slater was justified and reasonable pursuant to the revised code 2999.16. However, his motion was used as a mitigating factor as he was convicted of a lesser offense than originally charged. Because of this, appellant was not prejudiced in any way. Consequently, denial of the pretrial hearing was only a harmless error and by no means prejudicial to the appellant. So the trial court decisions should stand.
Any further questions?
No.
No.
Thank you, Your Honors.
Thank you. Any rebuttal?
Yes, Your Honor.
5 minutes, I believe.
Yes.
Okay.
May I proceed?
Please.
To clarify some of the questions that you asked my co-counsel during her portion, as to the emotional effects, you asked about that. Now, certainly a lot of those emotional effects could have been avoided had the pretrial, had there been a pretrial, and they could have decided whether or not he was immune, but they didn't. So now the best way to alleviate his emotions would be to have another trial to determine whether or not he is actually immune. Now next, as you stated, or as some of the questions directed at opposing counsel were as to what evidence there could have been found on the iPad. And there could have been no evidence, or the police were only permitted to search the iPad under the Thornton case if they had a reasonable belief that the iPad would contain evidence related to the crime.
But couldn't the iPad have been connected through the cloud and somebody remotely
Yes.
trying to destroy evidence that they're
Yes.
trying to get before the destruction?
Yes, that could have happened. However, given the facts in this case, there was not a shred of evidence that suggested that this could have been connected to the cloud.
But did they know that at the time?
No, they did not. But even if they even if they did not know that at the time, there was still no reasonable belief that they could have found evidence related to the crime on the iPad, whether it could have been destroyed or not. Now, opposing counsel stated that because it was not password protected, that it could have been searched. Now, that is not true in the case of both laptops and cell phones. Since an iPad is similar to both of these, we take the position that a similar standard should be applied and it can never be searched without a warrant. Next, opposing counsel stated that a house can be searched as long as it is incident to arrest. However, that is not the case. An entire house of a person cannot be searched. Specific rooms can be searched, but not the containers of those specific rooms. Only those rooms, and still only if it is to protect destructible evidence or to protect the police officers by conducting a search of the person or of his surrounding area. Now, next, opposing counsel also stated that it was necessary to search the iPad at the time because they needed to see if there were another hit on the hit list that could have been next. No, there are two problems with that. First, he was in custody, so there's no way he could have killed somebody else on that hit list. But second, they should not have searched it in the first place, so they should not have had a reason to search that hit list because they should not have conducted that search in the first place and then found out that there was a hit list. Now, next, opposing counsel stated explicitly that the trial did not cover whether or not, since there was no pretrial, there was only the actual trial. Opposing counsel stated that there was nothing to determine whether or not he was immune, only as they only used this evidence as a mitigating factor. That is not what the legislature intended. In fact, the legislature clearly and unambiguously states that there must be a determination of whether or not somebody is immune from prosecution and then prosecution. While it does not specify a pretrial, there should be some time when it is determined whether or not he is immune. You cannot determine whether or not somebody is immune from prosecution during prosecution. That is circular and illogical, and that is clearly not what the legislature intended. So for these reasons, we respectfully request that you overturn the decision made by the lower courts.
Does the appellant want a new trial? Is that what you want?
Well, preferably, we would want our client to have a pretrial first, and then if he is not immune in that pretrial, then the actual trial where that could be used as a mitigating factor. But it's also important to note that we do not know what evidence would have been let in at the actual trial since there was no pretrial. For instance, that hit list may have been excluded, and it may have been determined that that could have been excluded during the pretrial. However, there was no pretrial, so there could be a different result in the actual trial, even if he is not immune.
Thank you.
Thank you.
The scoring judges will now leave the courtroom. Thank you all for participating. This is a very important endeavor by the OCLRE, which is supported by the State Bar, the Supreme Court, the Attorney General, and the ACLU. And it's not just important if you want to be a lawyer. The skills that you're asked to develop in this process are very important. Let's say you're in business. You have to give a presentation in front of a committee or your 3 bosses. You'll be standing there doing a PowerPoint or something, and you got to think on your feet sometimes. And it also talks about writing. That's the other part, really not discussed today, but the writing, the clarity is all important, whatever your future holds for you. So this is a very important endeavor. We're glad you participated. Y'all did very well. I'm going to let the other judges start. What, John?
Start first. Yeah, sure. You know, definitely I want to echo my colleagues' praise of your performance today. You know, this is the type of skill that translates to a lot of different things other than just being a lawyer. And so it's really good practice. And one thing I will tell you is that everybody is just as nervous as you were. I know I was the first time I was on that side of the table. And you know, some people think it's some sort of like magical skill, or some people are just blessed with this, and maybe that's true, but for some people, but for most people it's not, and it's really something that you have to sort of work out and teach yourself. And you know, feeling comfortable up there is mostly really just a matter of how well you prepared and what kind of mastery you have over the material. And I thought you guys definitely showed that you did a nice job in the preparation stage, and so it showed today. So that's good. Maybe just a couple of sort of quick points. First, what I would say is that in oral argument, you really don't need all of the points that you would make in your brief. If you're going to try to hit like 6, 7, 8 different things, you'll never get there in the time allotted. And it's fair to assume that the judges have read the briefs prior to oral argument, and so you really want to just emphasize your strongest points, especially for petitioner's side. Respondents, sometimes you get a little bit of a choice of whether you need to address their arguments first before launching into yours or not. But so that might help on some of the organizational issues. Let's see, what else did I have? Definitely in responding to a question, I know there's a set order of things that you want to, like, you've got it outlined on in your notes about, I'm going to touch on this and then this. But if a judge asks a question that's out of order for you, tactically it's probably not a great move to tell them that you're going to get there later, simply because they won't listen to you until you actually get there. Because if they're asking a question, it's a good sign that they're probably interested in it, right? They think it's an important issue. And so to tell them, well, I'll get there in 5 minutes, for the next 5 minutes, the only thing they're going to listen for is when you get to the answer to the question that they had in mind. And so sort of being able to flip the order is a very helpful skill to have. I'll tell you that actually the way I practiced when I was in law school was I had all the different, if I had 3 points, I had 3 different index cards and just shuffled them and practiced giving them in whichever order. Let's see, I don't know that I had too much else. Maybe on the intro, I sort of understand why Petitioner in this case really wants to tell the story and give all the facts, but at the appellate level, that's probably not necessary most of the time, and it delays getting into the actual argument. Like I said, we've read the briefs. There's been a trial below. Facts are probably not as critical at this stage as they would be at the trial level.
The judge can ask for the facts.
Right. But yeah, so again, really nice job overall, guys. Definitely you should be proud of yourselves. So.
I'm going to echo everything John said, and I have just a few more points. I believe I heard a few times, maybe even on both sides, when especially when Judge Fisher was asking questions, the response started out with, it can be argued that, or that's an argument that. Don't say that, especially when it's on your side. If that's the argument for your side, that's the argument, and you make that argument. You don't preface it with, well, we can argue that. Argue it. That's your side. Advocate for that side. What else do I have? Roadmaps are important, and I think all four of you had roadmaps for your individual arguments, and in the first attorneys for each side kind of outlined everything that each side was going to hit on, which is helpful for the judges to anticipate what they're going to be hearing from both of you. This is something that I got picked on a lot when I was doing moot court in law school, and I especially caught it on your guys' side. Grant, you had a pen in your hand, and Evie, you moved your hands around a lot, and I get it. I do that too. I'm doing it right now. I move my hands all the time when I'm speaking. You don't need to have a vice grip on the podium, but it's distracting. I was watching your pen a lot, Grant, when you were speaking, and you were talking to me like this. And I get it. I understand that it's you don't even notice that you're doing it, but that's something that can be very distracting, and somebody can fixate on and takes away from what otherwise would be a very good, strong argument that you're making. You guys, I heard on both sides anticipated arguments from the other side and rebuttals to the arguments that you think the other side was going to make, or that the other side already did make. So that's good. You're adjusting your argument to what the other side has said or is going to say. I think that's all I've got.
I'm not going to repeat what they said. I agree with both of them. I think all of you had the ability to project your voice, and that's so important, very important. But when you project it, you must project that you believe in your case. It's not just being loud. It's, I believe what I'm saying. And I think you all did that. I think you all, or at least tried to do that. But you got to know your case so far down in your heart that that's what's speaking. Because even though it's logic and rational and all that, the other side might have a logical and rational argument. But when you project that inner value to the case, that can have a big impact on a close case, which, to be honest, that's what this is designed to be. I mean, that's the whole point of it. And I think that will help you, all of you, in your lives as adults, that if something's that important and you're a lawyer, somebody's life out of prison or in prison is at stake, that's big issues. Or cases we see come through, capital murder cases too. Person's life's at stake. Or we had one the other day, there's $80 million and the person's company would either survive and thrive or die. So there's a lot at stake. So putting that, you all have good voices. Just internalize the value of the argument. Other than that, you guys know the cases, you know what you're talking about, you know, which is important too, but that's just the start. There's that little icing on the cake that can make a difference in an oral argument. Not so much necessarily on the appellate level, but if you're, like I said, in business or at a trial level, that little, and I'm not even saying it's emotion, it's that you value your argument so much, and that comes through when you're speaking. And it's something that a lot of young people, you're nervous here to start out with. You might not be able to get to, but it's something that will help you, I think, the rest of your lives. And I think you all have it.
And I mean, to kind of put it in concrete terms, I mean, if you're not convinced by your argument, how can you expect any of us to be convinced by your argument? And the way that you present it shows whether or not you're even convinced by the argument. and will help sway a judge either way.
On a close case. Do you have any questions of us?